Thank you once again for attending today's session, being the second of a series of presentations that we are giving on the subject of alternative dispute resolution. Welcome back to those of you who joined us last Thursday, and welcome to those of you who were not at our last session and have joined for the first time today. Quickly, introductions once again. My name is Philip Sewell. I'm the head of the dispute resolution team in London, along with other partners who work in this practice in this particular area. And I'm assisted by a senior associate, Sarah Walker, who is qualified in both English and Scots law. And licensed to practice in both jurisdictions. Lily Manser, who is an associate based in London, and a junior lawyer, Gabriella Gilmour. We are, that's to say, myself, Lily and Gabriella, only qualified to practice in England and Wales. So if anyone has any questions, as occurred last time, that require Scots law input, advice and assistance, then Sarah is your lady for that. Today's session, following the introduction that we gave last week, will cover the following different types of alternative dispute resolution in a bit more detail, with each of us taking one or more of the topics to conclude with a presentation on them today. I'll be dealing with arbitration and mediation turning into an arbitration, and then subsequently we'll address adjudication, expert determination, negotiation, early neutral evaluation, mediation, and conciliation. There will be time at the end of this session for questions. The questions were posed last time, and there is a Q&A box for us to look at the questions and seek to answer them as best we can during the course of this presentation. We did receive a number of questions last time, and whilst we got through a number on the day, we answered by email. We're quite happy to do that again if we run out of time, or there's something that someone wants to ask us in a bit more detail that causes us to think more carefully about our response, other than giving an off-the-cuff reply. Last thing to say by way of housekeeping is that scripts that we have prepared, slides that are in existence, and what we intend to say today will be made available both by way of email and recording that will be sent to you if you're interested in receiving at the conclusion of this session. So, moving to the first topic of arbitration, as we touched on in our last session, the concept of arbitration, as opposed to litigation, is a private dispute resolution forum where an independent arbitrator, doesn't necessarily have to be a lawyer, can be a lawyer, but an expert in the field of the dispute that they are required to determine, is appointed by the parties to make a decision on a dispute that's arisen between them, which is intended to be final and binding between them, and is usually confidential. And that's one of the main reasons why it is preferred by protagonists to a dispute, as opposed to conducting the dispute in public before the courts. I'm conscious of the fact that talking as a lawyer and with reference to fairly arid issues can be dull, and we'll probably lose half of you within about 2 or 3 minutes or so. So what I thought I would do was just tell you about some experiences that we've had recently so far as the employment of an arbitration mechanism is concerned, and the sort of fields that we find that it crops up in on a regular basis. Sarah and I, supported by Lily a year or so ago, dealt with an arbitration that sought to resolve the price to be paid by the acquirer, being a football club, of assets, that's to say a Premier League stadium, a business centre, various other linked assets, training academy and so forth, for a Premier League football club. We've also conducted arbitrations in the field of leisure, hotel related work, and in oil and gas work. What we're finding is, due to the convenience of arbitration as a mechanism for dispute resolution, the sophistication of the matters in dispute, and the desire to keep things out of the court and for them to remain confidential between the parties as opposed to public, and Brexit issues that Sarah will touch upon in her presentation, we're finding arbitration is of great interest to parties as opposed to conducting their affairs before the court. Bit of arid, dry law, unfortunately, but just to give you the setting for this, the way in which arbitrations are dealt with is usually under the Arbitration Acts of 1996. That came into force on the 31st of January 1997, and it applies to all arbitrations that involve domestic disputes, that's to say between people or entities within this jurisdiction, and international matters, that's to say parties who are outside of this jurisdiction, about issues that the contract that they've entered into and that the arbitration provision relates to, which were commenced on or after that date. It governs all arbitrations with a seat of England, Wales and Northern Ireland. There are similar laws in Scotland, but we're focused on this jurisdiction, that's to say England and Wales. The idea of the Act was to introduce radical changes to the English law and practice on arbitration, and it sought to consolidate previous legislation and establish case law principles in harmony with international law, particularly the New York Convention, which in simple terms seeks to ensure that as between different states, awards or judgments are recognised and are easier to enforce than might otherwise be the case. What does the Act try to do so far as basic principles of arbitration as a mechanism is concerned? The answer to that is that the provisions of the Act are founded on three basic principles: fairness, party autonomy, and limited recourse to the courts. Try to keep matters away from judges and the court process. So far as fairness is concerned, the object of arbitration is to obtain the fair resolution of a dispute by an impartial tribunal without unnecessary delay or expense. What we're finding is that given lots of different reasons, I would say, with regard to the conduct of litigation before the courts, it's very difficult to get a hearing date for a trial in a complicated matter that might last, let's say, a month before any division of the High Court in London within, let's say, 2 years of the commencement of the dispute. And so therefore, the advice we're giving to clients is it's easier and we are more optimistic about being able to resolve disputes with reference to arbitration proceedings than is the case with reference to commencement of proceedings at a court. And there are all sorts of issues that arise in a commercial context when that decision is made. How quickly one can get the judgment, where are the assets that one wishes to enforce against, what might happen in the meantime so far as dealings between the parties or other commercial business imperatives are concerned, that weigh down on each of the protagonists, all sorts of things to do with access to justice and access to evidence, not least witnesses of fact or expert witnesses. Second principle, party autonomy. The parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. The consequences of this are firstly that the parties should be held to their agreement. Secondly, they should have the power between themselves to dictate by agreement how the arbitration should proceed, how it should seek therefore to resolve the dispute between them, and they should abide by its terms in respect of the outcome. Third principle, as I've said a couple of times now, limited court intervention. Reference can be had and as contemplated by the Act to court direction and control, but only as provided by the Act in specific circumstances. The general principle here is that the court should not intervene in the determination of the dispute between the parties. What's the seat of the arbitration? The answer to that question is the jurisdiction designated by the parties. In a sense, it's the legal home of the arbitration. It could be a chamber of commerce, it might be a particular entity that's been set up particularly to deal with arbitration disputes, either here or in Europe or in America, anywhere around the world, conceivably. And this, importantly, determines which countries' procedural laws will apply. It can be quite tricky, actually. Again, a bit of boring and arid law for you, but sometimes the parties determine that all disputes that arise between them are to be conducted by a particular arbitration tribunal, but they forget to say what the law should be that the tribunal should apply. And therefore, that takes time, so far as resolution is concerned, to ensure that the right body of law is referred to in the context of the way in which the arbitrators resolve the dispute. Very important, therefore, to think, as all lawyers who are drafting contracts try to do, to think about what would happen if in the event of a dispute and how it is to be resolved, and leave as little to chance or imagination or argument as possible. Make it certain as far as you can do that. So far as the seat of the arbitration is concerned, it's not to be confused with where the hearings take place. Usually, the seat of the arbitration will be the same as where hearings take place. But for example, if the seat were in France, the arbitration would likely be governed by French legal principles, but the hearing could, for example, be held in London. We've dealt with a number of instances where, due to the convenience of the parties and particularly the witnesses who are required to give evidence at the arbitration hearing, whilst a seat has been selected with reference to a preordained determination of how and where the dispute will occur, sometimes hearings are to take place away from that, just simply to ensure that costs are kept under control, matters are dealt with efficiently, and, for example, the arbitrator might want to visit a site, that's to say, in the event of a construction dispute, go and see what's going on the site, form his or her own view about what has occurred there that's given rise to a problem, and potentially conduct hearings from the site. In this day and age of reaction to pandemic and lockdown issues, we found that just as we're doing today, speaking via Zoom or Teams or some other form of communication of this nature has made it much more flexible and easy for matters to be conducted by arbitration in that private context to the convenience of everyone participating in it. Commencing arbitration and limitation, whilst the parties have got the ability to determine themselves how their disputes are to be resolved without intervention of the court, save in the way that I mentioned, What they can't do, however, is displace the consequences of the Limitation Act. That is to say, the date by which disputes are to be commenced in accordance with what lawyers would refer to as the date of accrual of a cause of action. In a breach of contract claim, for example, the accrual of the cause of action commences on the date of the breach itself. So 6 years from the date of the breach, as a simple illustration of that. The same is true in with proceedings as well. Arbitration is deemed to have commenced if the parties have named the arbitrator at the outset of the arbitration, and once one party serves on the other a notice in writing requiring them to submit the matter to a designated arbitrator. Sometimes you get arguments about who the arbitrator should be, or series of arbitrators, number that make up a panel, and that needs to be resolved with reference to court intervention if such an issue arises. If an arbitrator, however, is yet to be appointed, once a notice is served requiring the other party to appoint or agree the suggested appointment of the person who serves the notice, that's when the arbitration is deemed to have commenced. That's really important from a point of view of kicking off arbitrations in circumstances where people want to get on with resolving a dispute and have concerns about limitation issues. What is a tribunal? The party can generally choose their arbitrator, but cannot generally choose the judge if this were a litigation matter who presides over a trial. And so therefore there's a significant advantage in doing that. It may not be that you like, if you read as a lawyer, as we do, the judgments of some judges who seem friendly or pro or biased to particular types of litigant. We act for all sorts of different individuals and entities, but mainly we are a firm that deals with corporate and business entity related disputes on behalf of such a party, and with regard to the conduct of those matters, I'm always keen to see who the judge is, who is going to be dealing with the matter, which will inform my advice given to the client. Once I know who that person is, I know what his or her thinking will be on a particular topic and where their biases might be. If you can select an arbitrator, you influence the ability to ensure that the way in which you want the dispute resolved is according to just exactly how you'd like it to go. Can't obviously tell them what to do, but you can have more confidence in having control over than we found if they are expert and skilled in their field and able to resolve the dispute before them. It's possible to have one arbitrator and efficiency and costs rather dictate the fact that that's what should occur. You don't have to have one arbitrator. You can have a number of arbitrators who are skilled in particular areas of dispute. We found that's been helpful in respect of complex matters. But the key thing to bear in mind here is that the parties pay for the services provided by the arbitrator. Other than paying court fees when claims are issued at court, and as matters progress through the court system by what's known as case management conferences or pre-trial reviews, for example, the only payment that is made in addition to the payment to a lawyer acting for a party, so the only payments made to a call is the issue fee and the fees at case management conference and pre-trial review matters and the like. With reference to an arbitration, anything that the arbitrator does or any assistance that the arbitrator requires from, e.g. a legal assessor or an accounting assessor, which view might be expressed to assist the arbitrator with resolution of disputes regarding how, for example, to value an asset in the case of accounting. All of that is paid for by the parties. So be mindful of the fact that whilst parties have autonomy and speed of resolution, can be expensive in respect of the cost that a party is put to, so far as resolving a dispute is concerned. An arbitrator can be removed by application to the court on the instance of one or indeed both of the parties, or more if there are more parties to an arbitration than just simply two, where there is doubt as to the arbitrator's impartiality, their actual capacity to act and do what they're required to do, whether they possess the requisite qualifications or they've conducted proceedings in a particular way unreasonably, without dispatch, or they've made an error with respect to the way in which they've undertaken matters. That may sound unusual. It may sound that that's not the sort of thing that happen on a very regular basis, but believe you me, there are times where arbitrators stray outside the remit of what they've actually been asked to do, go off on a frolic of their own and decide things that they're not required to decide, which impact upon the outcome between the parties. And additionally, it may be the case that your client, who is a party to arbitration, might say to you, for example, this dispute is about the valuation of a property, but I want you to get the arbitrator to determine additionally whether there is an obligation not only on the part of the other party to buy the asset, let's say it's a hotel, but also to determine what should be paid in respect of the business conducted from the hotel. And what we would have to say in those circumstances, as an example of disputes that arise in arbitration, is no, the arbitrator is only instructed to deal with valuation of the hotel asset property. He is not entitled to, and would not be in your interest, to prejudice the arbitration if he strays outside of that field of valuation of the property by looking at, is there an obligation to purchase a business conducted from the hotel, and if so, at what price? Those sorts of practical problems are given rise to on a regular basis throughout an arbitration, we found. We have to manage them, give advice in consequence of them when they arise. What are the arbitrator's duties, and what does the Act impose upon the tribunal as an obligation? In general terms, to act fairly and impartially between the parties, to give each party a reasonable opportunity to put its case, to avoid unnecessary delay and expense, and adopt suitable procedures doing all that's necessary for the proper and expeditious conduct of the arbitration proceedings. So what that means is, if it's necessary to have witnesses of fact talk about why there's a crack in a wall, for example, in a construction dispute, there'll be directions made with regard to exchange of evidence and for witnesses to give statements and talk to them and be cross-examined over their content, just in the same way as court proceedings occur. So far as expert evidence is concerned, what we found here is that some arbitrators are very keen to be guided by experts in a particular field with reference to what they see as being important for them to have knowledge about. But generally speaking, the arbitrators we appoint are experts, skilled and highly intelligent and able to resolve disputes themselves with reference to their own knowledge about matters. So one of the benefits of arbitration is that if you were to appoint, for example, a surveyor to work out, valuation expert to work out what a property is worth, you might decide to pick someone who is senior so far as RACS membership or fellowship is concerned. That person should know themselves how to resolve a dispute and what approach should be taken with reference to valuation of an asset. The judge in litigation wouldn't necessarily know that. Judges are lawyers and are not expert valuers, surveyors, engineers, whatever else it might be. So we found with arbitrations that you can take it intuitively and as read that arbitrators should know what they're doing and ought to be able to resolve disputes within the particular field of their expertise or competence. Moving on very swiftly to the supportive powers of the court during an arbitration. As I've said a couple of occasions now, the court should not intervene except as provided for in the Act, and they may only exercise some of the following powers, but only if necessary. They can enforce what's known as a peremptory order, where there's been a breach of the tribunal's procedural directions, specifying a time for compliance, and get hold of what the arbitrator is seeking to do with regard to a resolution of dispute quickly. The court can issue witness summonses to compel certain people who have something relevant to say to attend before the arbitration and to give evidence. They can be, a judge can be asked to make an interim injunctive order to preserve evidence, property or assets, if there's any risk at all, before the arbitration, during the course of the arbitration, before the award is made, of dissipation of assets. The court could also, to assist the arbitrator, be asked to determine a preliminary point of law. So if something exists that the arbitrator is struggling to resolve and would like guidance from the court on a point of law, hasn't asked for a legal assessor to be paid for by the parties to assist him or her, then the court might be asked to say, what is the answer to this legal question? And then the arbitration will flow and resolve matters by reason of the court's answer to that. Awards and costs. Like in litigation, an award is a final and binding determination unless the parties agree otherwise. Tribunal may make a final award dealing with all of the issues in dispute, or a partial award dealing with only a discrete issue. So far as costs are concerned, the Act contains provisions that basically say that the general principle that exists in dispute resolution, that costs follow the event, that's to say the winner recovers costs, is the case in an arbitration, but the tribunal also has discretion to award them on a different basis. What we found is that judges are quite reluctant to make an issue-based cost order or a proportional cost order, with a few exceptions that I won't dwell on, as opposed to in the context of arbitration, where an arbitrator has much more flexibility, discretion, and willingness to approach things in a particular way, so far as resolution of costs is concerned. So just by way of experience, what we found is that's the approach arbitrators take relative to the complex litigation cases that we are also involved in, given the practice in particular before the commercial court. Wrapping up this section on arbitration, challenges to awards are not overly common, and there are very strict time limits for challenging awards. Just pausing there. The issue that arises in litigation is that an application for leave to appeal can be made as of right in relation to outcomes in judgments. Whether or not leave to appeal is given by a more senior court, I won't touch on here, but our experience is that challenges to arbitration awards are much, much more restrictive, and so therefore, once the award is to hand, as long as it's been arrived at in a manner which is correct, reasonable, doesn't offend any of the matters I referred to earlier, then the person in receipt of the award and who's looking to enforce it should be generally optimistic and comfortable about the fact that challenges to that award, as opposed to challenges to judgments in litigation, will mean that they will get the justice that they have sought to achieve quicker and more efficiently, and less cost involved in that process. Challenges to awards are to be made within 28 days of the date of the award, and can be made on one of the following grounds. The award was made by a tribunal lacking substantive jurisdiction. The arbitrator was appointed incorrectly, shouldn't have proceeded that way. Alternatively, there's been a serious irregularity that's caused or will cause substantial injustice. The arbitrator's gone off on a frolic and done something that he or she shouldn't have done, and that's going to cause a result for the parties which is incorrect and unreasonable. Thirdly, the award contains a mistake of law. That concludes what I wanted to say on arbitration. Just very quickly, in the context also of arbitration, it's possible for parties who have opted to resolve disputes that have arisen between themselves by way of mediation, and there's more to be said about mediation subsequently, for the mediation to proceed. And if it doesn't resolve the dispute, for parties to agree to matters to be referred to arbitration. This is a hybrid process, combining therefore a normal mediation with arbitration. As I've said, if the mediation fails, either in whole or in part on an issue, the parties may agree the mediator becomes an arbitrator and issues a final and binding award on the outstanding matters. It's entirely flexible, so the parties can refer outstanding issues to another of the processes we intend to cover, overseen by an independent neutral party. A short arbitration is followed by a session in which the arbitrator attempts to mediate the dispute, and if settlement is not reached within a specified time, the arbitration award is handed down. What's the advantage of that, one would question? Well, principally, the parties will benefit from the flexibility of the mediation, try to convince each other of the merits of what they are seeking to achieve by way of resolution. But unlike mediations generally, where there's no certainty of a binding outcome, an arbitration award gives that outcome, what's to be seen as binding between them. It may mean, additionally, so far as mediation is concerned, that they can work harder to negotiate a settlement to avoid an award being imposed on them if it then moves to arbitration. And it combines two ADR processes, keeping the matter out of the court again, avoiding all the time and costs in undertaking a legal dispute before the courts that I mentioned earlier. Problem with mediation arbitration techniques is that it may lead to the mediator not being able to enter into frank discussion as to the merits or disadvantages of their case, so far as that particular part of the process is concerned, let's say the mediation issue, before one moves to arbitration. But nevertheless, it avoids the issues that I've mentioned so far as court processes are concerned. I've spoken for 20 minutes or so, so what I'm intending to do now is to hand over to, I think, Sarah's next in respect of the issues that she will cover. Thank you very much for your time and attention.
Thank you, Philip. That was a very useful overview. So as Philip mentioned, I'll be covering two forms of ADR. Those are adjudication and expert determination. I've got quite a lot to cover and not a lot of time, so I'll do my best. Please bear with me. Hopefully I'll be able to deliver it in a comprehensible fashion. If not, it's been recorded, so you can slow me down if that's necessary when you revisit this, should you wish to do so. So taking adjudication first, what is it? Well, at its most basic, it has a number of similarities to other forms of ADR. It's a private form of dispute resolution that involves an independent, impartial third party who considers the claims of each side and makes a decision based on submissions and, to the extent necessary, its own investigations. And generally, it works to a very tight timetable. Now, it's widely been recognised as a pay now, argue later mechanism for resolving disputes, or I've also heard it referred to more controversially, perhaps, as a quick and dirty form of ADR. Now, to assure you, the dirty did not refer to any form of impropriety in terms of the quality or validity of the decision making. It's been labelled as such because of the practical reasons for which adjudication was developed, and that is rooted in construction contracts and projects, and a need to resolve disputes on an interim basis very quickly, perhaps slightly roughly, primarily to avoid cash flow issues and substantial delays in the overall construction project. So when can it be used? Well, generally speaking, it can only be used if adjudication is stated as a term within a contract, and that's referred to as contractual adjudication, helpfully, or the dispute relates to a construction contract, which, as I'll explain in a moment, is often referred to as a statutory adjudication. Now, finally, it can also be used by agreement when a dispute has arisen and it's not provided for as a mechanism either by way of a contract or in a construction contract, and this is referred to as ad hoc adjudication, and this is where the parties will make a separate agreement to refer to the existing dispute, so the dispute at the point it has arisen to the form of adjudication. Now, the mechanism, given its origins, which I just touched on, is without a doubt and unsurprisingly probably most commonly used in resolving construction disputes. And for that reason, my focus will be primarily on those types of disputes. And indeed, in the UK, adjudication is a mandatory right in disputes that arise under a construction contract. And a construction contract is defined in Section 104 of the Housing Grants, Construction and Regeneration Act of 1996 as amended. And that's often just referred to as the Construction Act, thankfully for me. And parties cannot contract out of that. Now, in my opinion, it's often overlooked outside of construction disputes too readily, so please do bear it in mind, as it may be appropriate for a number of different kinds of disputes. For example, it's well placed to deal with a range of commercial, house and land matters, including, for example, service charge cases, or indeed those that are involving the provision of substantial amounts of goods or services. So now I'll very briefly just run through a basic overview of the adjudication process. So first of all, there needs to be two conditions that are met. The first one, there needs to be a claim under contract. And as I said, usually that is a construction contract, but not exclusively. And crucially, the dispute must have crystallised. So if it has not crystallised, it cannot be validly raised for adjudication purposes. And this it's important to note because a court will refuse to enforce an adjudicator's decision that is based on a notice of adjudication issued before the dispute has crystallised. So if that adjudicator's decision has to go into enforcement, the court will refuse to do so if the dispute had not crystallised prior to the notice being issued. So once those two conditions are met, there will then be service of a notice of adjudication. The adjudicator will then be selected and appointed. The referral will then be served, followed by service of the reply and any other submissions. The adjudicator can then, if necessary, make further investigation, and then the adjudicator's decision will be provided. And that will be followed by enforcement of the decision if it's not complied with. Now, at that stage, there could also, of course, be a challenge to the enforcement of the adjudicator's decision. Now, I mentioned at the beginning, the process is run on a very tight timetable, and that is because from the date of the notice being served, adjudication is generally a 28-day procedure, i.e. adjudicator's decision should be published no later than 28 days from the date of the notice, albeit this can be extended by agreement between the parties. Now, the speed with which statutory adjudication is dealt with reflects the purpose of this form of ADR introduced, and specifically, as I said, in relation to construction projects, i.e. it's designed to protect cash flow, it's designed to facilitate the ongoing works of a construction project. But note, whilst adjudicator's decision is a binding adjudication, does not necessarily finally dispose of the matter. So in real terms, what you might find is that the adjudicator's decision will last until, in example of construction project practical completion, at which point it may then be litigated or subject to arbitration proceedings if one of the parties so wished, i.e. if they were not happy with the adjudicator's decision and they wanted to revisit it, that is a possibility. So that must be borne in mind. So now that you have an idea of the process and the idea behind the development of adjudication, I will, as quickly as possible, just canter through some of the advantages and disadvantages. And by doing so, it will hopefully give you a greater flavour of some of the process more generally. So advantages to adjudication, as I've touched on a number of times now, speed. Adjudication offers a speedy means of resolving disputes. It is, as I mentioned, a 28-day procedure unless extended by consent of the parties, which in all honesty, it often is, because 28 days is quite the quick turnaround, but that is what statute states. Now, the Technology and Construction Court, which is a court often tasked with the process of enforcement, they have developed the procedure equally as quick in respect of enforcement of adjudicator's decision, with them also aiming to deal with the matter within 20 days. Now, in reality, I'd say that's more of an aspirational timeline. It does tend to take a little bit longer, but in the grand scheme of things, it is a relatively quick process when considering the amount of work that the courts have to undertake at the moment. Another advantage is limited disruption. Again, as I mentioned, disputes may be referred at any time. That's what the statute states, which means that it allows a party to speed up the resolution of issues that may otherwise have jeopardised or disrupted the completion of the contract or project. And the tight timetables often ensure that work can continue while the dispute is resolved. It is cost effective, so adjudication usually is much cheaper than certainly litigation and indeed most other forms of ADR. And this is primarily down to the tight timetable. Preparation costs are inevitably curtailed because of this tight timetable. And in adjudication, each party usually bears its own costs, meaning that the referring party certainly avoids the cost risks involved in litigation and also arbitration. So in most cases, the cost of adjudicating a dispute will more than likely be lower than other forms of dispute resolution. Further advantage levied at adjudication is the relative cost effectiveness of adjudication balances out financial inequalities. So the advantage of fairness, effectively, that where there's maybe financial inequalities that exist between the various parties, this is somewhat neutralised by the cost effectiveness of the procedure. Further advantage is privacy. Unlike court proceedings, adjudication proceedings are private. I will note that the only exception to that is if the adjudicator's decision has to be subsequently enforced, because that involves the court process. But in terms of any adjudication hearings, those hearings would be held in private. Another advantage is choice of decision maker. So a party can choose who adjudicates its dispute. Obviously, this is a luxury not available to court users. They cannot, unfortunately, choose their judge. And in terms of the choice, it doesn't have to be a lawyer. It often, in fact, isn't a lawyer. It will be somebody with particular expertise, such as an architect, an engineer, or a surveyor. But sometimes it is a lawyer if the particular dispute is sort of legally heavy, i.e. interpretation of a contractual provision. And a further advantage is flexibility. And this is an advantage levied at a number of ADR processes, and adjudication is no different. The terms of the contract may specify a particular adjudication procedure. There are a number out there, but if not, the parties generally are free to choose which adjudication procedure will apply, or can set that out in their contractual provisions. So flexibility, a key advantage. But it is not all rainbows and unicorns. As they say, there are potential disadvantages to adjudication, and these perceived disadvantages are rough justice. So the tight timescales of the adjudication process may mean that an adjudicator is rushed through and has to make somewhat a rough and ready decision on the matter. And, you know, there can be considerable legal or factual complexity to those issues. So it could lead to injustice, and court proceedings may be necessary to right that injustice, leading to some form of duplication of legal costs. There is the prospect of irrecoverable costs, because a party's adjudication costs are not usually recoverable in the adjudication, and further adjudication costs are not usually recoverable in subsequent litigation, although there has been some case law to the contrary of that, but the general position is they won't be recoverable. A further disadvantage is the concept that a party can be ambushed somewhat, because the referring party can effectively take the respondent party by surprise. Now, this is avoided in litigation because we often have to comply. In fact, we do have to comply with pre-action protocols. But it's worth noting that the adjudicator does have to comply with the requirement of natural justice and ensure that they have enough time to reach a fair and impartial decision within the timescales agreed by the parties. So that disadvantage is somewhat curtailed by the adjudicator's professional duties. And a final disadvantage, and it is it is a significant one to consider. It regards insolvency. So if a respondent party who has to pay money to a referring party in accordance with an adjudicator's decision, then subsequently challenges that decision, and the decision is reversed by way of litigation or arbitration, but the party has in the meantime gone into insolvency, then the likelihood of recovery is very slim. So that's just a very, very quick canter through the pros and cons, as it were. I'll touch very briefly on enforcement. There's no machinery in the Construction Act in respect of enforcing adjudicators' decisions. So the Technology and Construction Court, which, as I mentioned, primarily deals with those issues, have developed their current procedure, and it's set out in Section 9 of the TCC guide. Now, the TCC's approach is to uphold the adjudicator's decisions robustly unless the adjudicator plainly has no jurisdiction or there has been a breach, a material breach of the rules of natural justice. So the TCC will not interfere with an adjudicator's decision, even if the adjudicator has made an error in procedure, fact, or law. So it's very, very difficult to successfully challenge an adjudicator's decision at that stage. Now, there was initially some support in case law that the approach with regards to the enforcement of statutory adjudication was different to that of contractual adjudication, but subsequent and binding case law has settled that issue and confirmed that the same test or approach applies to both, though there should not be any distinction between them. Now, enforcing adjudicator's decision in Scotland, the enforcement of an adjudicator's decision in Scotland does differ from England and Wales. Unfortunately, looking at the time, I definitely do not have time to cover that at the moment, but if it is of interest to you, please do let us know, and we can certainly cover that off at a separate time. I could talk considerably more on adjudication, but I don't have the time to do so, and I do want to touch on another form of ADR. So I'll draw a line under adjudication there. I hope what I've said has been helpful, and just very quickly move on to expert determination. So expert determination generally is a binding dispute resolution process that can offer a relatively quick and cost-effective means of determining, in particular, disputes of specialist or technical nature. So it's less suited to resolution of matters which are likely to give rise to extensive factual disputes which require the review of, for example, extensive documentary or factual witness evidence. It's also less well suited to purely legal disputes, and typically actually expert determination clauses don't envisage the appointment of legally qualified individuals. So it's well recognised as resolving disputes in a lot of areas of commercial life. Although it is possible to arrange expert determination on an ad hoc basis, it is usually provided for in the commercial contract by way of a dispute resolution clause in the agreement. It's a fairly generalized point, but I would say an accurate one. Expert determination clauses arise most commonly in the context of two areas. The first one is where some form of variation is required. We've been involved in a number of those. And the second is where an expert scientific or professional opinion is needed to resolve the dispute which has arisen. So why use it? Advantages of expert determination. It allows for the appointment of an individual who's familiar with the relevant specialist or technical issues to resolve the dispute. It is usually cheaper, quicker, and less formal than certainly arbitration or litigation. It often helps the parties maintain business relationships, and it is also confidential and generally less adversarial than certainly litigation and arbitration. Crucially, also, it can dispense the need for the parties to instruct their own independent expert witness, which can be very expensive in of itself. And an expert can adopt more of an inquisitorial investigative approach that is often unavailable in other forms of dispute resolution. But, and there is always a but, as you'll know, the law on expert determination is not well developed or as well developed as other dispute resolution mechanisms such as arbitration. And this is key, and where I would encourage you to seek legal support, as in the absence of a well-drafted expert determination clause, this can lead to uncertainty, it can lead to additional delay, and it can lead to additional costs while that uncertainty is resolved by way of satellite litigation, which is what you want to avoid. You certainly don't want that to be the outcome. Also, there's a lack of established procedure and rules to support the process. So an expert's remit is entirely dependent on the contractual provisions. Again, why I would encourage you to seek legal support in respect of getting those drafted. And generally, there's no backup rules of procedure and process. So as there would be in a dispute that's been resolved before a court or arbitration. So for example, there's generally no possibility for an expert to order a party to disclose relevant documentation. So it could be difficult for experts to ascertain the truth in the event of a significant factual dispute if the parties aren't willing to cooperate. And that is why I said often it is less well suited to those types of disputes where there's a heavy factual element. Brief mention to the procedure. Procedures adopted by the experts likely to be dependent on the terms of the contract. As I said, that will be supplemented by the experts' often detailed terms of reference. And as a very final point, I'll just mention the ability to challenge the expert. So the grounds for setting aside an expert determination are generally very limited, unlike a court judgment, and to a slightly lesser extent the award of an arbitrator. It cannot generally be appealed or otherwise challenged. Therefore, the parties must decide whether or not they want to be able to challenge the expert's decision on any particular basis. And if they do, they need to include that in the terms of the contract. Again, just highlighting the importance of getting that right. If the parties don't expressly provide for otherwise, it's likely that the expert's decision will only be open to challenge on the following grounds. That is fraud or collusion, impartiality, so where the expert appears to favour one party over another by a various number of methods, material departure from instructions, failure to provide or state reasons for the decision. I'll add one slight one onto the end, which is manifest error, but this is an interesting one because absent a provision in the contract, even if the expert is manifestly wrong, it may not be subject to change. But to overcome this oddity is very easy. What you need to do in the contractual clause is to state that the expert's decision is final and binding in the absence of manifest error. So without that, even if the decision is patently wrong, it's usually not susceptible to challenge. So just a last tip for you before I depart my part of the presentation, which is now. Now, I was going to be handing over to Gabriella, but I have noted the time, so I'm not sure if we're still sticking to the original timetable. I will pass back, I think, to Philip, who'll say one way or another.
Thanks very much. That was very thorough, comprehensive, and interesting. What we will do, given the time, is leave mediation to another session that we will conduct in September, as it's such a large topic, and Gabriella will therefore speak on her matters to conclude. We haven't today got any questions that I can see in the chat box, so question and answer functionality. So Gabriella, over to you, and I think we can then conclude at 10 o'clock. Thank you.
Thank you, Philip. So I'm just going to touch on negotiation first. Of the different ADR processes, negotiation is the one with which you are all most likely to be familiar to some extent. And as discussed last week, negotiation is the most informal and flexible option and is the only non-binding process without third-party intervention. So the parties retain control, and the nature and extent of negotiations is entirely up to the parties. They usually proceed on a without prejudice basis, and the rationale for this is to encourage parties to settle their disputes out of court, particularly as discussions are best facilitated if parties can speak freely, safe in the knowledge that what they say or offer to try and settle a matter may not be used against them should the discussions fail. Now, negotiations can remain entirely private. Both the dispute itself and any settlement reached can remain confidential, and an express confidentiality clause is commonly included in the terms of any settlement agreement. So negotiations can be undertaken at any stage of a dispute, and as with the recent matter some of us were involved in last week, they can take place right up until trial, and it is very often at the 11th hour, in our case the evening before the hearing, with the pressure of the dispute coming before a judge and most significantly an uncertain judgment thereafter, that the parties finally reach a settlement. A compromised but agreed outcome is more likely to be acceptable to both parties rather than just to the successful party in court. Of course, if there is any prospect of settling, it is generally better to achieve it sooner rather than later. And this is largely because the longer the litigation runs, the higher the legal costs. But also, obviously, the CPR and courts expect the parties to consider the possibility of settlement at all times. So in terms of achieving settlement, it's very important to formalize a settlement agreement once it has been successfully negotiated, usually in a written and binding contract, which can then be enforced through the courts. As with the matter I mentioned we dealt with last week, it is essential to have any agreement finalized and signed before you take any steps to stay or discontinue proceedings. This is because despite thinking you've agreed a position, negotiations can later stall due to any one of the various terms which are usually included in a settlement agreement. And you would not want to make the mistake of discontinuing proceedings before these are all ironed out. Now, where negotiations take place after the commencement of court proceedings, the parties can agree to embody the settlement agreement in a consent order or judgment. And this will enable the agreement to be enforced within the existing proceedings rather than having to start new proceedings afresh should you need to. And then in terms of conducting the negotiations, they may not even involve lawyers necessarily. However, it is often the lawyers negotiating on each party's behalf, and in our experience, this tends to be the best approach so as to effectively progress the discussions without damaging existing commercial relations and so as to save disputes from becoming personal. So even if the matter does end up going to trial, negotiations can narrow the issues in dispute and therefore save costs going forward. They may also flag aspects of the case which need more information, and if this is provided, this in itself may help promote settlement. Furthermore, they might encourage the parties to reevaluate aspects of their respective cases, and this can facilitate future settlement opportunities, or indeed whether a party starts proceedings at all. On the other hand, discussions may fortify a claimant's confidence in a particular position and make proceedings more likely to go full steam ahead. Negotiations can become deadlocked without an independent or neutral third party and the more formal procedures. However, having opened the dialogue, parties may be willing to try a different form of alternative dispute resolution if negotiations do not succeed. And that leads me nicely on to the next ADR process to cover finally, that being early neutral evaluation. So early neutral evaluation, or ENE, can be particularly useful in cases where negotiations have become deadlocked or where there is a large disparity between the parties' positions. The process is confidential to the parties involved, aside from the involvement of the independent and impartial evaluator. The aim of ENE is to provide the parties with an objective and realistic view on the strengths and weaknesses of their respective cases. And this can serve as a basis for commencing or recommencing further negotiations, but it can really be used at any stage of a dispute. It's particularly useful where one party has an unrealistic view of its prospects of success or has been given an over-optimistic view of the merits of its case. And it can provide a sort of reality check for clients and can helpfully identify the weaknesses and any gaps in their evidence. An ENE may relate to issues of facts, evidence, technical issues, or legal merits, or a combination, but it may not be suitable for cases involving disputes of fact where witness evidence is required. So the process is voluntary and can only be carried out with the agreement of all the parties. Though the parties lose control of the outcome of the evaluation, this does not result in an imposed settlement, and nor does the evaluator attempt to force a party to accept proposed settlement terms. The evaluator does not resolve the dispute or even necessarily make suggestions as to how it should be resolved unless they are asked to do so. They just express a view on what the outcome would be if the matter proceeded to a formal dispute resolution process, such as arbitration or litigation. So the choice of the evaluator is often key to the quality of the evaluation. They must be seen to be independent and impartial and possess the relevant expertise in the subject matter. The parties can either appoint the evaluator directly by agreement or use an organisation to make the appointment, such as the Chartered Institute of Arbitrators. The depth of the analysis provided by the evaluator will vary according to their expertise, the time they have been asked to devote to the task, and the materials presented by the parties. Now, the parties, together with the evaluator, will usually enter into an Ene Agreement, and this sets out the details relating to the content of the Ene, what is to be expected of the evaluator, and when the evaluation is to be delivered. An agreement tends to include the evaluator's duty to act impartially, the documents the parties are expected to produce, the procedure and timetable, whether it's without prejudice, as I explained earlier, and whether the evaluation is non-binding, which it usually is. It will also include the evaluator's fees and how costs are to be borne, whether the evaluator will be limited in scope or whether they can consider other matters or request additional information from the parties, and whether the parties are permitted to ask questions or seek clarification once the evaluation is issued. So usually the evaluator is expected to produce a reasoned evaluation of the merits of a case as opposed to a non-recent one. So there's no set procedure. It's entirely for the parties to decide and agree upon. It is not subject to due process like arbitration. The parties and evaluator will agree whether the evaluation will take place on the basis of written submissions and documentary evidence only, or on the basis of a hearing. And unless the parties agree otherwise, the evaluator can conduct their own investigations, inquiries, and research. It's really important for a balance to be struck between the parties preparing sufficiently so that the evaluator has enough information to give a persuasive and informed view of the outcome at trial, and then not spending too much time and costs on preparation to render the Ene effectively like preparing for a full trial. And the costs of the evaluator are usually shared between the parties, and then each party usually bears their own preparation costs. So the evaluator usually writes an evaluation that is handed to the parties, but the evaluation is not a full decision. It's simply a summary of the evaluator's view of the merits of the case. It will usually include an assessment of the strengths and weaknesses, an estimate of the likely outcome, and then suggestions, if any, for resolutions. However, as mentioned, the scope depends on the instructions given to the evaluator from the outset. So to finish with some advantages, even if it does not result in settlement, the process narrows the issues and can focus the parties' attention on the more important aspects of a case, and it can facilitate discussions by encouraging the parties to move towards a realistic starting position. It can be cheap, though in large scale or very complex cases, the extent of preparation required might render the Ene disproportionately expensive without the certainty of settlement. It can also be undertaken on relatively short time scales, subject to preparation time and the evaluator's availability. Then the potential risks of engaging in Ene to flag are that one party may become entrenched in its position if the evaluation is in its favour, and this could hinder settlement. Similarly, it may then be difficult for the losing party to recover from this, which may in turn compromise that party's negotiating position. Finally, a party could spend a large sum of money obtaining an evaluation which it considers fair, but which the other side simply refuses to acknowledge. However, if the process goes to plan, the parties usually arrange a negotiation once an evaluation is issued, or they may agree to hold a mediation as part of the procedure. And I'll end there, and we will have to pick up on mediation in our next session. Thank you.
Gabriella, thank you very much for that really helpful overview. Again, very thorough. It's great, thank you. Just to conclude here, we have a couple of questions, one about enforcement of an arbitration award, the other to do with the way in which the arbitrator would deal with choice of law. But let's push them off to another day when we will pick up on the subject of mediation. We'll answer those questions then. Thank you very much for listening in. I'm sorry we've overshot by about 4 minutes. We hope that's been of use to you. The slides and presentations will be made available by email along with the recording, and we will be advertising a fresh date for us to deal with the subject of mediation, possibly also with an arbitrator speaking, and we'll get that to you as soon as we can. Thanks for staying with us, and enjoy your summer holidays. We look forward to seeing you again. Thank you very much.